Action SA has filed an urgent application at the Electoral Court to challenge a decision by the IEC to exclude its name on the local government election ballot paper. The party apparently wrote not applicable when asked to provide an acronym or abbreviation for its party name. But Action SA has cried foul and accused the IEC of bias. So what are its chances of succeeding? Let's get you some perspective now with our next guest. Tselane is Executive Chairperson of the Institute of Election Management Services in Africa. He joins us via our video link. Terry, a very good morning to you. Indeed, it's a busy time for you, no doubt, in the build-up to our own local government elections here in South Africa. This issue really couldn't come at a worse time for Action SA.
Absolutely. It's a very difficult moment for Action SA, but it's also equally difficult moment for the Electoral Commission because, as you may be aware, that the preparations for these elections have been interrupted by quite a number of events, and then this does not make it any easier for the Electoral Commission.
I mean, let's break it down for our viewers what this actually means. If indeed Action SA does not win this court application against the IEC, it will mean when we go to the polls and we have that ballot paper in front of us, there'll be Action SA's logo and there'll be two empty blocks next to that logo. Who knows what voters are going to make of that?
Absolutely. I think that is likely to create confusion to a voter. And I'm just hoping that the Electoral Commission will interpret the regulation governing the section that deals with casting a vote or marking a ballot paper liberally in order to make sure that this is not, it does not disadvantage political parties such as Action SA.
Yeah.
The reason I'm saying this is now when you've got a particular box in a ballot paper allocated for a voter to mark in order to indicate their preference. Now, in this case, you would have two empty ballot boxes. It would mean that sometimes a voter might actually put a mark in a wrong box trying to indicate their preference. So I'm hoping that whether the marks are in both boxes or in an empty box that is not really allocated for a position where a voter has got to put a mark, the Commission would still accept it as indicating the preference of a voter.
I mean, would the IEC give clarity around that ahead of the elections to say, you know, if there are two markings, two X's, for example, in those two empty squares next to Action SA's logo, we will count that as a vote for Action SA? Does the IEC explicitly have to say that?
Absolutely. The Electoral Commission has got an obligation to do that, particularly because it is an aspect that can create confusion for a voter during the election. So the Commission has got a responsibility to make sure that there is no confusion, but also to make sure that the political party is not unfairly disadvantaged by an error of this nature.
I mean, Action SA and its leader, Herman Mashaba, saying all sorts of things about how it's being disenfranchised by this decision by the IEC. Herman Mashaba calling it, I don't think it's exactly the same word he used, but something to this effect, that it's sort of a random decision being made by the IEC. What do you reckon here, Terry? Is the IEC, on the face of it, in the right here?
You know, I can understand the frustration coming from Action SA in relation to this particular aspect. But the Commission, I think, has implemented Section 15 of the Electoral Commission Act in a manner that it's supposed to. As you may be aware that in order for a political party to be registered as a party, it must meet certain minimum requirements. These minimum requirements are outlined in Section 15 of the Electoral Commission Act, and they include the fact that a political party must have the name, must have a symbol in color, and then must have an abbreviation of that political party, and other requirements include having to pay a deposit that has been set for a party to participate in the process of the elections, but also to submit their constitution as well as a deed of foundation. Now, the aspect that deals with the abbreviation, gives an impression that it is an option. In fact, it does not give an impression that it's optional. It is optional. So if a political party is not focusing properly, they may think that there is no need for them to put any information on that particular aspect, which is what happened in this case, in the case of ActionSA. But it is increasingly becoming clear that the Electoral Commission also has got the responsibility now to educate political parties about the disadvantage that may arise as a result of them not being able to fill certain information. But the Commission has applied the law in terms of Section 15 of the Electoral Commission Act, and the obligation is on the political party to submit that information that they're supposed to submit in order for them to be registered as a political party.
Yeah. I mean, what this means for ActionSA now is that, you know, in the run-up to elections, and we've got 20-odd days until we go to the polls, instead of focusing what ActionSA can do for communities in terms of service delivery, there needs to be a lot of education around what the logo for ActionSA is if indeed the party doesn't succeed before we go to the polls on November 1st in this court application.
Absolutely. I think they've got a major responsibility and a mammoth task of having to make sure that the voters understand that logo, even though it does not have the abbreviation, still represents a political party. So those voters who really would want to vote for ActionSA would have to be educated to be able to cast the vote for a party that they prefer, using the symbol of that political party.
Yeah. On the face of it, Terry, you reckon it's not going to succeed in this court application?
I think it's unlikely for them to succeed, particularly because the obligation was on them to supply the information. That information was given to them because immediately after registration of a political party, the chief electoral officer has got to provide that political party with a registration certificate which indicates all the details of that party that party has actually submitted. But not only that, the chief electoral officer also has to issue the registration details of that political party in a government gazette. So there are processes that they would have gone through in order to arrive at this finality of having the kind of information that they have for the registration of a political party. So it's going to be extremely difficult. But at the same time, I would assume that because if the matter is taken to court, there is a possibility for anything. The Electoral Commission would also be preparing for Plan B just in case, ActionSA does win this one. Difficult as it may be, the Commission has got an obligation to make sure that this is not going to be disrupting their processes. But I think the fortunate thing is that ActionSA does not actually contest all the municipalities in the country. There are about, I think, 6 metros that they are contesting. And therefore, the Commission, in terms of its Plan B and the preparations, should easily be able to deal with that should the court come to a determination that they've got to include those details in the ballot paper.
I mean, Terry, just given what you've just said now, the fact that it's not contesting in every single metro in the country, there is still time, perhaps on the face of it, for the IEC to include its name on the ballot. Why not just do so?
No, because the Electoral Commission is obliged to apply rules and regulations according to what the law says. Now, if information has been given by a political party, they can't deviate from the information given. And they don't have the discretion to provide such information for a political party. Right.
So even, because I've got the government gazette in front of me here, so even when in point 3, ActionSA answers to the question, the abbreviation in the name of the party is NA, as in not applicable, it was never up to the IEC to go to ActionSA and say, look, this is going to disenfranchise you, you should probably give us an abbreviation.
Absolutely, it is not an obligation, particularly because in the manner that that section is structured, it says abbreviation, if any. And that is important because then it gives an impression to a person who is writing that it is not actually obliged to provide that kind of information. But like I said earlier on, I think going forward, the Commission has got the responsibility to educate political parties about the implication of the decisions that they take in relation to matters like this. It is not only this issue, but quite a number of issues where there have been some hiccups in preparation for these elections. The Commission would have to jack up its role in terms of educating political parties through party liaison committees so that they understand what is acceptable and what is not acceptable, and then what is likely to advantage or disadvantage.
Right, right. Yeah, absolutely. Perhaps also more so with smaller, newer political parties. Terry Tselane, it's always a pleasure talking to you. Thanks very much for clarifying some of those big issues for us. ActionSA filing that urgent court application with the Electoral Court. That's to challenge the decision by the IEC to exclude its name on the local government election ballot paper. Terry Tselane is with the Institute of Election Management Services in Africa.